What's going on, everybody? Welcome back to another episode of Let's Talk Live. This is episode 4, a little bit out of order here, but I want to welcome everybody into the live show this evening. We have an action-packed special show for all of you. I hope you're liking the new background, the graphics that I worked on this afternoon. And also, I worked on some new emojis. So go down and check out the emojis there. You can use those throughout the live. I got a special treat for all of you that we're going to be bringing in here in a little bit. But what a very interesting day in the Idaho case. Bryan Kohberger was back in court today. Lawyers on all sides were fighting this gag order. We're going to get into that. We're going to play the segment of the court released video from Kohberger's gag order hearing today. There's also been some motions about cameras in the courtroom. We may get into that this evening. And there also was another motion that was filed today for a extension of time by the defense. So lots of interesting things going on. And you all know that I cannot do this alone. So we're going to bring in the panel tonight. I got 2 special guests for you all. First, I'm going to bring in my confidant, my I don't know, just someone that's been very devoted to this channel, someone a huge supporter here, a mod, a friend. Agent Chase is back. Laura, how are you?
Good. How are you?
I'm good. And it's good to see you back on the live. We love having you over here. The audience loves seeing you as well. And guys, go down there and check out the emojis. I made a special Agent Chase emoji, so you can type that in the chat tonight and give her some love in the chat. And of course, I could not do it without the voice of reason as well. It's like that godlike voice. We're going to bring him in. AZ's back on the show. How are you?
Hey guys, how you doing?
It's good to hear you, man. You know, it's funny. I always say, I have to say this. You know, my mods, the people that have become very close to me, I appreciate everything that you guys do, especially for me, because you keep me very balanced. And sometimes when I want to strike out and maybe say some things, or maybe have some conversations on the channel, before I say it, you guys sometimes say, you really want to think about that. And we were talking about that today, and I appreciate that advice, keeping things balanced here on this channel, because we want to stick to the facts and we don't want to get crazy and say things that just are foreign out there. So thank you, Laura. Thank you, AZ. I really do appreciate that.
You're welcome. Always a pleasure to be on and to work with you.
For sure. I agree.
I can see the so I got, it's just everybody knows, I have Laura's little icon up there, her little detective icon. And then what I did for AZ is his cup, the what you talking about, Willis. So feel free throughout the show to pop those emojis in and give these guys some love.
Oh, you're kidding. That's awesome.
Isn't that cool? It's cool, right?
That's amazing.
I want to welcome in all the subscribers, the brand new subscribers. The channel's blowing up here. We're on our mission to 10K. I think it's going to happen soon, and that's great. It's very exciting. And I want to welcome all the channel members, all the new channel members that support monthly. It's been a great ride so far. So we got a very kind of relaxing stream for all of you today, but we're going to get into some of the things that kind of surrounded this whole Bryan Kohberger Idaho case. And so the first thing I wanted to talk about today was there's a new motion that came out, and I'm not sure if either of my panel guests got to review it. I'm pretty sure they did. But let me just enlarge this here. So this was a motion by the defense. It was a motion for exception or an extension of time. And we'll look through this document here. And we'll just read through some of this here. So it says, "Come now, Bryan C. Kohberger, by and through his attorney, Ann Taylor, public defender, here request the court to find good cause for an exception or in alternative extended time for compliance with the Idaho Code 19-519. This motion is made on all grounds that IC 19-519 authorizes the court for good cause shown to order exception to compliance with the statute. Good cause for an exception in Mr. Kohberger's case exists. Since Mr. Kohberger's arrest in late December, the prosecutor has disclosed 51 terabytes of information that includes thousands of pages of discovery, thousands of photographs, hundreds of hours of recording, further or many gigabytes of electronic phone record and social media data that has been disclosed. Discovery is, I'm going to screw this up, voluminous. Did I get that?
Voluminous?
Yeah, and still ongoing. Mr. Kohberger and his defense team continue to both negatively discover, disclosed by the state, and investigate the charges against Mr. Kohberger. Compliance with IC 19-519 is at minimum premature, as wading through the extensive information that makes up the case is incomplete. Compliance with IC 19-519 may tread into disclosure of protection information. The defense needs time to make the determination and consider evidentiary rules. As such, Mr. Kohberger respectfully requests an exception or compliance with IC 19-519 or an extension of time. Should the court not be inclined to grant this motion, counsel requests that this motion be set for hearing in order to present oral argument, evidence, testimony in support of, therefore, request time of 15 minutes, dated on the 9th of June, 2023. So things here in this case are moving extremely fast now. You know that we're getting close to the October trial, maybe, if it happens. I think it's still going to happen maybe in 2024. And before we speak on this, I just want to put this out there as a disclaimer. We are not lawyers. We are not experts. We are no way affiliated with any type of law enforcement. You're basically just getting opinions and kind of water cooler talk here. And also, I also want to remind the audience too, if this is the first time that you're checking out my channel, that Bryan Kohberger is the alleged person that committed these crimes, but he is innocent until proven guilty. So I'm going to go around the panel first. Laura, what do you make of this? What do you think of all of this? Do you think this is a tactic, or do you think they're thinking this is unfair, that all this evidence kind of got dumped at the defense and they didn't have time to look through it? What do you think?
Well, what I always do, I looked up Idaho statutes, Title 9, Criminal Procedure, Chapter 5. So this 19-519 is notice of defense of alibi. And it says, at any time after arraignment before a magistrate upon a complaint and upon written demand of the prosecuting attorney, the defendant shall serve within 10 days at such different time as the court may direct upon the prosecuting attorney a written notice of his intention to offer a defense of alibi. So he needs more time to enter a defense of alibi. I don't understand it. If you have an alibi, you have an alibi. It shouldn't depend on what the prosecution has on you. So and then it says, such notice by the defendant shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. So he needs more time to establish an alibi, according to Idaho Code 19-519. I'm puzzled as to why, if you have an alibi, you have an alibi. I don't know why you need more time.
I would think that. AZ, any thoughts?
Well, Laura, what is it? The first thing I noticed was this term on the second to the last paragraph, page 2, where it says Kohberger and his defense team continue to both navigate discovery, right? Like, I mean, that's just a giant sea of data, right?
Right.
Yeah. So they obviously want, timestamps and bookmarks and all that sort of thing, right, Laura? Isn't it?
I mean, what I'm assuming is that before he is going to make a statement of what his alibi was or is, he wants to know what all they have on him, so then he knows where to frame his story. So if he knows they have him at 1122 King Road, then he needs to come up with an alibi as to why he was there.
Right.
But if they don't have him there, then he can say he was at home, at the bar, at a coffee. You know, the list goes on. So
taking a casual run at 1 o'clock in the morning.
Yeah, it was just going on a run at 1 in the morning, which he did do. Okay, so we'll give him that.
Well, that's why I said that.
Yeah. So, I guess, you know, I would think if they have been provided lots of this discovery, they've been provided the discovery. It's obviously extensive, as they say, voluminous, and still ongoing. Obviously, he's still trying to figure out what they have on him. This, I believe, actually doesn't help him. This makes him look worse, in my opinion.
Yeah.
This makes it look worse for him.
I have to agree, in my opinion. Let me just recognize this real quick. Jessica Crockett has become a rookie detective. I've now named my membership level. So rookie detective, we just want to welcome her in. So, yeah, I mean, this extension of time is a little weird. To me, I mean, if I was to look at it, a little bit of a stall tactic, in my opinion. But, you know, that's kind of what I have to say about it. I thought it was just very interesting. Very, very interesting motion.
Brian, can I see if I can take another whack at this?
Yeah, go ahead.
So we talked a little bit earlier about how they just dumped that giant, what was it, 51
terabytes.
Yeah. In you know, my memory's a little hazy, but wasn't the defense rushing them to hand that stuff over?
Yeah,
And
they were saying, like, you haven't given us anything. Where is everything? And then the prosecution went, here you go. 10,000 photographs, obtain hours of video footage. I get kind of where you're going to go with this as well, too. You know, it's kind of been dumped on our laps. But let me ask you, is it the prosecution's, and I don't know how this works in a setting of law, but would it be the prosecution's responsibility to itemize all those items for the defense? Isn't that why they hire experts, for people to go through that stuff for them?
Well, I would think we touched on this a little earlier too. I think that like we were talking about the UPS video, sure, for example.
Yep.
What did we just kind of ballpark? That could have been around 1,000 hours. Yeah.
Yep.
So I mean, if the whole purpose of that UPS surveillance footage was in fact just to sort of see if he was in that area
sure,
that week, and if they caught him on 3 seconds just driving by, and now the prosecution hands over 1,000 hours, says, there you go, there's 3 seconds of Kohberger in there somewhere, go ahead and find it.
Right. No, fair enough.
Yeah, it's not exactly in the spirit of what would you say?
Fair game.
Yeah, yeah.
I don't know. Is there fair game and try? But I guess there's fair game.
Well, I guess, I mean, the better the more fair, or the more cordial the defense party or the lawyers are to each other, I guess maybe the smoother things go, sure, for everybody sometimes.
Yeah.
I don't know.
Yeah, I think I can agree with some of those points as well too. I see where you're coming from, and that's what I love, that we all have different opinions on this on the panel. It makes it fun. It makes it balanced, and it's really good. So Duck Farts says that's a lot of discovery. The judge may order the prosecution to sort evidence. It's a great point. It's a really great point.
Yeah, I think that just seems reasonable to me. If you have, if you have footage of evidence of him in a certain area at a certain time, then hand it over. Don't hand us this is what I would say if I was the defense. What, are you going to hand me a week's worth of, you know what I'm saying? Sure. A week's worth of data or a week's worth of surveillance video, and I've got a rifle through it looking for 3 seconds. Help me out.
Of course. Jane says, Bryan seems uncomfortable sitting between the two women. I wonder why. Seems so uncomfortable sitting between the two women. I wonder why. We'll get a little bit more into that later on because I want to try to get to the video. So, you know, we'll finish up and wrap on this. I did have a couple of other videos planned, but I don't think I'm going to go through those today. But I do have an article that I want to share with everybody. And of course, my article is gone. So give me about 2 seconds. Let me just pull up this article. Hang on. I just had it. Recently closed. Sorry, everybody. I had this pulled up earlier. Let's see. I think I got it. Nope, that's not it. Oh, no, it was. Damn it. Hey, bear with me. Here it is. Yeah, let's do this. I had a couple of videos I was going to pull up, but we can just use the article. And I do want to go into the hearing because I think it's important that we play that. So let me pull this article up. We'll read through a little bit of this and then get into the hearing. So basically, this is what happened in court today. I'm going to enlarge this a little bit so we can all read it. So from Court TV, a judge overseeing the case against Bryan Kohberger, charged with killing 4 University of Idaho students last fall, heard arguments Friday over a gag order that largely bars attorneys and other parties in the case from speaking to news reporters. A coalition of more than 30 media organizations has challenged the order, saying it violates the Constitution, guarantees free speech and free press, as has a lawyer for one of the victims' families. But the prosecutors and the defense lawyers insist that it needed to prevent prejudiced news coverage that could damage Kohberger's right to a fair trial. So it says here, Bryan Kohberger's defense team wants cameras banned in the courtroom. It remains appropriate to have an order reminding lawyers that they're agents of the rules of engagement in this country, and that we try court cases not in the press. One of the Kohberger attorney, Jay Logsden, wrote in a memo to the court this week. Kohberger, 28, is charged with 4 counts of first-degree murder and burglary in connection with the stabbing deaths of Moscow, Idaho, November 13, 2022. Second District Judge John C. Judge entered a not guilty plea on his behalf last month. Prosecutors have not said if they will seek the death penalty. The bodies of Madison, Kaylee, Xana, and Ethan were found in a rental home across the street from the University of Idaho campus. The slaying shocked the rural Idaho community and neighboring Pullman, Washington, where Kohberger was a graduate student studying criminology at Washington State University. The case is garnered widespread publicly, and in January, Latah County Magistrate Judge Megan Marshall issued a non-dissemination order barring attorneys, law enforcement agencies, and other associated with the case from talking with to the press or issuing statements unless they're quoting directly from court documents. The Idaho Supreme Court in April declined to vacate the gag order, saying the news organizations, including Associated Press, should have first asked the lower court to lift the order. The justice did not weigh in on whether the gag order violates First Amendment rights. The news organization subsequently did ask the lower court to revoke the order, and judge scheduled arguments for Friday. The media coalition says that while it respects the defendant right to fair trial under the Sixth Amendment, the court should not have issued a gag order without evidence that that right would be infringed by the ability to speak with attorneys involved in the case. Interveners agreed that there has been and will continue to be great publicity surrounding this case, in coalition attorney wrote, but publicly alone is not prejudice. The state and the state and Mr. Kohberger's failure to present any evidence as prejudice news coverage and the court failure to consider alternative measures means that competing constitutional rights here would improperly balance, and the gag order should be vacated. The gag orders that prohibit journalists from writing about certain cases are considered to be severely problematic under the First Amendment. I'm not going to read too much more of this, but I kind of understand what's going on. But I do want to just read this sentence. So Shannon Gray, an attorney for the Gonzalez family, had also asked the judge to lift the gag order, saying he should be allowed to speak on the behalf of the attorney. So what I'm getting this is you have First Amendment free speech, you have the Sixth Amendment right to fair trial, and then you have a family. So everybody's battling on that. And then you have the family attorney, Shannon Gray of the Gonzalez family, fighting that it should be lifted because I'm pretty sure they have things that they want to talk about. Extremely interesting day in court. What do you all make of this? I'm going to start with Laura first. What do you think, Laura? It's crazy. This is crazy.
Absolutely. I'm just
going to say this before you speak. I don't think anything is going to go smoothly in this case. Just already seeing what's been happening.
You know, I think of this case like a choose your own adventure book in some ways.
Right.
You start reading the story and then you get to this paragraph where it says, if you decide to blank, then turn to this page. That's what it's like. I mean, any, judge, he seems like he's quite a character, and we have a whole panel of attorneys here that are quite the characters. So I think, if anything, this is going to be some good court TV for us.
Yeah, I think so. Real quick before I go to AZ, C. Vanderhoof says, Brian, I got my hands on a copy of the Kayla Jade poster for you. That is amazing.
Awesome.
That's awesome. Please email me at Let's Talk Live Podcast, and we'll figure out a way to get it to me. I'll pay the postage, whatever. I appreciate you doing that. But please reach out to me. Let's Talk Live Podcast at gmail.com. All right, AZ, what do you think?
Well, I'm a little behind on this one. So both the media and the family, or at least the G family,
right,
wants it lifted, right?
Correct.
Yeah. So, and is it just the G family, or are they kind of? It's just them.
It's the G's. Yep, it's the G's. And then essentially what's happening is that the prosecution and the defense lawyers are saying, we really should leave this in place to preserve the integrity of the case. But I'm sure that the Gonzalez family has something to say. And, obviously, I don't think they're held under gag. They probably could say stuff, but probably under the advice of their attorney, they're not right now. But if the gag is lifted, they have that opportunity to talk. So.
Sure. So that's great. So Gray is representing them. Who's the attorney for the media? Or there's a coalition, right? For one thing.
Coalition. Yeah. They just put in a motion. Yeah.
They must have had the coalition must have hired a lawyer.
Yeah. I can't remember her name, but yeah, it's a woman that she's kind of leading the charge.
Gotcha.
Yeah, there's so many motions, there's so many documents, there's so much news. It's literally sometimes so hard, even just as creators, to keep up with everything. And now more information is going faster and faster every single day. I mean, we used to be really on, I have to admit, I used to be really on top of this, but there's so much that's come out. It's hard to catch up sometimes. So, I get it.
It's like history class. There's more and more of it every year.
For sure.
Yeah.
So let's do this. We did have a hearing today. I had two other videos I was going to queue up. I'll pull this one up first. Everybody's favorite News Nation host, Ashley Banfield, but I think she does make some great arguments in here and some points, I think, for both sides of certain cases, where they're going to talk about this gag order hearing, and then we're actually going to play the hearing and go through that. And then if we have time at the end, we'll do a little question and answer session, because I love doing that with everybody. So let's play through this really quick and see what Banfield has to say.
Ashley, you've been following this case from the start. Isn't this gag order, isn't the horse already left the barn? There's already massive widespread speculation about this case.
There's already widespread, massive speculation, but there is a mountain of evidence that we don't know about yet. And I have to say, Elizabeth, there's so much that I find fascinating about the debate that's going on. It's the First Amendment versus the Sixth Amendment. Your right to free speech in this country, and then your right to a fair trial in this country. But I've covered arguably bigger cases than Bryan Kohberger. OJ, for one. We didn't have a gag order in OJ, and we had cameras in the courtroom in OJ, and he had an acquittal.
Yep.
I'll also remind you that Casey Anthony also didn't have a gag order, had cameras in the courtroom. It was massively consumed across this country. She was called the most hated woman in America in headlines. Also an acquittal. Jodi Arias, she wasn't acquitted, but she skirted the death penalty. Her jury ultimately voted against a death penalty. Again, massive coverage. So I'm not so sure I buy into the arguments.
I'm just going to pull this up, and I don't know if I'm going to challenge. I guess I'm challenging this. So Beautiful Messy Ball says widespread massive speculation largely spread by Banfield herself. Do you think that maybe some YouTube channels are responsible with that as well? I'll just leave that thought. I'm not going to go on and like talk about any channels, but I'm sure that there's been a lot of fringe channels that have popped up that have said a lot of things that aren't true in this investigation, that have said things for clicks and views to, to a channel that may have just started a month ago. They pop in and drop some video like, I had a phone conversation with the guy that lived under the stairwell, and it gets 100,000 views on it, and people start believing that theory. So I think there's some of that out there too. So if you want to challenge mainstream media, you have to look at other social media as well too, and just keep it balanced in that sense.
That are being made by the prosecution in this case. And I will say, as you are too, we have a dog in this fight.
Right. Here's what I understand why the media wants that's our job. We want the information. It's the family's argument that really is sort of striking here, because they want the gag order lifted as well.
So they feel as though they have been treated almost the way that we have. They feel that they've been left out of the process. They don't know much. This is devastating to them. They'll come into court today and they'll see he's not in a jumpsuit, that he's in the black suit, and they don't understand why, because no one is sharing information with them. And what a lot of our audience might not know is that Bryan Kohberger has a lawyer. There she is sitting beside him. It's Ann Taylor. She's from the public defender's office. The families also have a lawyer. They're sitting across the way. They're called the prosecutors. And so the families aren't really feeling as though the prosecutors are their lawyer, because they're not part of the process. They're being kept sort of under the gag. They're not allowed to have information shared with them. And you can understand, as families, many times there's stuff you have to keep away from them. But generally speaking, they are part of the process, more than this process that at least I'm witnessing.
And what about this move to ban cameras
Brian?
during the trial? Bryan Kohberger's lawyers are.
Go ahead.
So what she just said, I mean, that sounds like that might be in part, at least, what it's all about for the G family, right? Is they're not getting any, so the prosecutor can't tell them anything. Nothing, right? Because there's a gag order.
Yeah, they're not getting any information, I'm sure.
So it's not simply the fact that they can't talk to the media and tell the media what's going on. It's that they're not hearing anything either from the prosecutor, right?
Right.
It's not, yeah.
Yeah, I mean,
I think all I've kind of heard for a while or the impression I've gotten is people are kind of saying, well, Steve wants to be able to talk to the media so that lift the gag order, okay, all right.
I mean, they have been, but I'm sure there's certain things that they can't say, or certain things that they probably run by their attorney. You know what I mean? They're not going to go on the air and say, hey, we know what I'm just saying, we know what the murder weapon is or whatever, don't take that literal. I'm just, saying that, but I'm sure there's things that they have to go by their attorney, or I'm going to talk to this certain person, or we may go on this network. Is it okay if I talk to, this news organization or whatever? I'm sure he's guiding them in that too, to not fuck anything up, essentially, because, because of what we're seeing now that unraveled today, you know what I mean? So, yeah, I mean,
I think I'm just now realizing that this gag order, I mean, the prosecution can't even say anything to them about.
Yeah.
I'd be curious to know how much the prosecution can say to them in a case like this with a gag order.
Yeah, that's a good question, because they've been saying since day one they haven't heard anything. We're not getting anything. We're not hearing anything. And I think that's what's opened up a lot of the people with the speculation that, some of the conspiracy theories that have been put out there, like, oh, they're not sharing anything. It's a big frame job. I think that's where all that stuff comes from. So
did they start saying that when the gag order started, or from the very beginning?
The very beginning of the case, because
Gotcha.
the G's were coming out and saying, hey, we're not even really hearing anything. And that's the big cover up. They're covering it up and they're making a story up and framing this person and that person. So yeah, it's been since day one, man. Well, what I mean is, have the G family, have they been saying that they haven't been hearing anything since day one, or did that start when?
Yeah. Okay.
Yeah.
Okay.
Pretty much. All right, we'll keep playing through.
Arguing against cameras?
Yeah, he doesn't want cameras. I get it. Who wants to be on trial for a horrible, despicable murder that no one can sort of get their minds off of? Here's the problem. There are plenty of countries around the world that don't allow cameras in the courtroom, that don't allow reporters in the courtroom, that don't even allow due process. They just put a hood over you and throw you in a gulag, and your family never finds out what happened to you. That's not America. We're actually the shining light in jurisprudence all around the world because we have a transparent system of justice. I will fight tooth and nail as long as I remain a citizen of this country that we should protect that at all costs. And I also feel strongly about the Sixth Amendment. But there is a balance. And I think what's being argued here is that without cameras in the courtroom, this will be the second massive trial in Idaho. Lori Vallow banned cameras in the courtroom. This shouldn't be the precedent. This shouldn't be.
We love questions like this, and we love, sometimes if you're challenging us, because it keeps the show fresh, it keeps it balanced, it gives, it gives you a voice to speak on how you feel, and we'll give you an answer. I'm not afraid to not agree with someone. Believe me, I'm not afraid to do that. And it's okay. You can speak your mind. That's what this chat is for. And it's for us to pull up and talk about and discuss. Absolutely. We love it.
The standard. I just cited the cases before you. I cited 3 of the biggest cases in the last 20 years in this, well, I should say now 30 for OJ, where they got fair justice. 2 acquittals, 1 guilty verdict, but an avoidance of the death penalty for Jody. So cameras, in my opinion, do not affect the jury. It is the jury that matters in this case. And when you have a camera in the courtroom, that horse left the barn. That jury's already seated. The cameras don't pan onto them. They don't get to see what we get to see. They are forbidden to consume media coverage. So why on earth would you say cameras are a problem?
All right, we've got 10 seconds left. What do you think the judge is going to rule on both the gag and the cameras in the court?
Oh, boy, I knew you'd do that. Look, betting man, I'm not too happy with what I'm seeing in Idaho lately. If Lori Vallow's any indication, they've been keeping everything secret. I just can't see that the new judge in this case is going to do anything different than the old judge in this case. Now we're at state level. We were at district level or magistrate level before. I don't think it'll change.
All right. Ashley Banfield, I hope you're wrong. But it was great to have you on the show as always. Have a great show tonight.
I know.
And have a great weekend.
All right. So yeah, I just want to play a little bit of that. I think Ashley, as much as people hate her, I think she made some good points there. And what we're going to do now is not spend too much more time wasting. We will play the hearing. And Judge, if anybody didn't see this, said that he considered all the arguments today. He wasn't going to make a ruling on it. He was going to give it to another hearing. He'll look over what all the points were. I'm sure there'll be some other motions that are filed, and we'll get a little bit deeper dive into this, gag order. But I do want to pull up Titanium Built's in the house. Hey, good to see you over here. I know I've been spending a little bit of time in your chat lately. If you haven't gone over and checked out her channel, check her out. She's been doing some Idaho 4 stuff over there as well. And, when I have a chance, I usually pop over. She's someone newly that I discovered in my algorithm. But it's cool to see her over here in the chat hanging out. So let's do this. You guys ready to go through the hearing? We'll see Mr. Kohberger in court today and see what we got. Sound good?
Yeah.
All right, cool.
Absolutely. Can't wait.
All right. Let me know if there's any point that you want me to stop and go back, or you need me to rewind something. I have no problem doing that. And then maybe at the end here, we'll do a couple question answers from everybody in the audience, and then we'll end up the stream. So, all right, we'll take it away. Mr. Kohberger in court today. All right. Judge. Am I blurry? Is that better? Okay. Oop, where'd everybody go? Bring it back. It's the panel. There we go. So first thing I want to say, you're seeing Mr. Kohberger now in a suit. Looks a little bit more cleaned up. They've got that orange jumpsuit off him, so they're, cleaning up his appearance, making him like a client, and I think going forward, you'll start seeing him looking more like this as we get closer to trial. I'm going to just speed this up until we get to someone to the podium, so we're not wasting time. That's not my feedback.
Okay, so let's get on the record.
And I do think the G's were watching the stream today from home.
We are now on the record. This is State versus Bryan Kohberger.
Hey, Laura. Good to see you. Hope things went well at the World Series of Poker. If you haven't done that yet, check out your channel.
On the Gonzalez family's motion to appeal, amend, and/or clarify intended dissemination order that was filed back on February 3rd, was delayed because media sought some relief from the Idaho Supreme Court. There was a delay to find out what the Supreme Court was going to determine. And this morning we have the state represented by Mr. Thompson and Mr. Rudley. Mr. Kohberger is in the courtroom, represented by Ms. Taylor and Mr. Watson. And I believe
Yes, Your Honor.
And I believe some of the family is participating, observing on Zoom. So before we get into the arguments, I want to address the Gonzalez family and all the families, really. Didn't really have an opportunity to do this at the arraignment. My heart does go out to the families. And the loss to your children is devastating and horrific. There's no dispute about that.
I ask you guys a question. Do you think that's interesting that he said that right off the bat? I mean, I might just be pulling something here, but do you think it's normal proceedings for a judge to talk like that?
Okay. I'm sorry, I was in the chat.
Sure.
What did he say in particular? Is this about being sick?
He started off, he said, I first want to speak to the families, the Gonzalez family, that, it's extreme loss that, you lost your child, and speaking to the other families that this is a tremendous tragic loss. I'm kind of just paraphrasing here.
Okay.
But do you find that interesting that I don't know. Do you find that anything interesting about that? And I might just be picking something, to kind of pick on.
I actually give him a lot of kudos for doing that, because
Sure.
he's showing his human side. I know he'd spoken about being sick at one point. I don't know if we got, I was doing 3 things here listening. This is like the 5th time I've listened to this. Sorry about that. But I think he's trying to humanize everything.
What's that?
I think he's trying to humanize everything.
Sure. So I'm probably just picking a pick.
No, I don't think.
All right,
AZ, anything?
I think he's being considerate. He's acknowledging the difficulty of the whole situation, and now here they all are in the courtroom, and it's gonna get rough. I think and so why not start it off? Go ahead.
This is going to be a rough case. I think
Yeah.
we're going to find out a lot of things. I think we're going to hear a lot of things. I think there's going to be a lot of things that shock people in this case, even myself, because we really don't know. We don't know all of the evidence. And that's the thing that I try to get across to all these, all the viewers that watch our channels, all the other creators that create on this type of this case. You gotta wait, because it's all not out there, and we're not experts, we're not lawyers. That's why we look to channels like The Lawyer, we look to Emily D. Baker. I say those names a lot because, in my opinion, they're very, very credible. They don't bullshit. They just look at the evidence and say this is what it is, and they have experience. Like I said, we're not lawyers. We're just trying to do and give our best opinions on this. So, but there's going to be a lot of that.
Before you start, Pamela's comment.
Yeah.
Ted Bundy was quite the looker. He didn't look like he was a serial killer. And I know even with the movie and the miniseries that was on Netflix, now, of course, it wasn't Ted Bundy. It was Zac Efron. However, it had people looking at Ted Bundy saying the same thing. Like, he doesn't look like a madman. He looks like, a good-looking guy. I'd go out with him. And so looks can be deceiving. You're right, Pamela.
At the same time, it is hard to look at a person, just a person that now is just sitting there in a suit, and how could anybody do something like that? So it's,
and we don't know if he did or not, but we're gonna find out. So all right, let's keep playing through this here and see what we got.
Acknowledge and apologize, because at the arraignment I did stumble over a couple of names, Kaylee's name and Raymond's name, and I want to explain that. I was up all night, really ill, probably food poisoning, and I was not at full potential. Probably also some emotion and nerves as I read those names. And I'm sorry. So that's my apology for that. I know some people were concerned about that and wanted to address it. I also wanted to explain a procedure at the arraignment that apparently drawn from the media that some people were confused when Mr. Kohberger declined to enter a plea. And I just wanted to clear that up, because I didn't really see any explanation about that in the media. That is Mr. Kohberger's right. And under Rule 11A1 of the Idaho Criminal Rules, this is a quote: if a defendant refuses to plead, the court must direct the entry of a plea of not guilty. That is not unusual. But reading the media, it seemed like somewhat mysterious. So I wanted to explain that, particularly to the media. It's a small issue, but it's somewhat, I think that I have an obligation, just as the media has an obligation, to help to educate the public about the processes that we are responsible to follow in the courtroom, and that's important for journalists. That's also important for the citizens. So, if you're curious about that, you can always find the criminal rules on the Idaho Supreme Court website. And it's very, very easy to read them and maybe get a better understanding. All right, so that's my speech for today. Mr. Gray, come on up.
So we're going to start with the Gonzalez family attorney, just so everybody can understand that.
And
If you allow me just a minute or two to get sorted out here.
take your
Appreciate
time.
it.
Take your time. Thank you, Mr. Gray.
Can I proceed, Your Honor?
Yes. Thank you, Mr. Gray.
First, Your Honor, we'd like to thank you for apologizing to the victim's family. I think it was an emotional day for them, and they appreciate your apology. I know that they took that part up. Thank you. I would first want to start with the procedural history of this non-dissemination order, if I could. On January 3rd, 2023, the Judge Marshall submitted a non-dissemination order. And in that order, it applied to parties in the action, which would have been the prosecution, the defense, and any agents, investigators involved in. After that non-dissemination order was issued, I reached out to the prosecutor's office to see if I could get Judge Marshall's email. For some reason, I don't know if they took it down, but I couldn't find it online. And they informed me that they were not privy to give me that information. Then on January 13th, there was a Zoom call that was requested by Judge Marshall. That Zoom call was requested at 1 o'clock on the 13th. I received an email at 12:58 from Judge Marshall's clerk requesting a Zoom call to speak to all interested parties. The Zoom call occurred at 4 o'clock p.m. During that meeting, the judge reminded us, all the parties involved, it was the prosecution, it was the defense, it was myself, it was the attorneys for the victims' families, the attorneys for the witnesses, I believe were there as well, a number of attorneys, and reminded us that her non-dissemination order mirrored that of Idaho Rules of Professional Conduct 3.6. As part of that hearing, and I think it's details here, she talks about the rule applies to all lawyers participating in the Zoom meeting, the state and the defense, and all attorneys for the witnesses. When she had that Zoom meeting, and I've requested the transcript from that Zoom meeting and haven't been able to receive it yet from Judge Marshall's court, so we could have a full transcript of what went on that day. But as part of that meeting, I had questioned Judge Marshall regarding the victim's family and whether or not they were allowed to speak to the media based on the fact that she had said all interested parties as well in the initial non-dissemination order.
Hey,
I
Brian.
didn't receive any clarification.
When was that, the initial dissemination order? I thought he started this out saying January 23rd, but this Zoom meeting happened on the 13th, he's saying, right?
Yep.
So do we know when, Laura, do you know when the date of the non-dissemination hearing? Or
Pull it up. See.
I can probably tell you in just a moment.
Yeah, I'm
just curious
too. Hang on.
Because he started when he said the 23rd and then backed up to the 13th for the Zoom meeting. So if the 23rd is when it was issued, then the Zoom meeting would not be under the gag order, right? And that was between the prosecution, the defense, the victim's defense, the witness lawyers.
On January 3rd, the defense wanted the non-dissemination order.
Right, I see it now.
So that was on January 3rd is when the defense said that.
When the defense requested it?
Yes.
Okay, so it was not in place on the 3rd.
Actually, it looks like and then later on that day, they ordered that the parties to the above titled action, including investigators, law enforcement personnel, attorneys, and agents of the prosecuting attorney or defense attorney, are prohibited from making extrajudicial statements, written or oral, concerning the case, other than a quotation from or reference to, without comment, the public records of the case.
So that was on the 3rd.
January 3rd.
Okay. So then 10 days later, they had a Zoom meeting on the 13th. And 10 days after that, January 23rd, the defense and what was he? Geez, okay. What was he talking about the 23rd then?
Want me to rewind it so we can hear it again?
Well, if you guys are interested, I mean,
Yeah,
I'm curious about it.
Okay, let's rewind it a little bit. Let's see. Let's go back a couple minutes. We'll go back here.
Attorneys for the victim families, the attorneys for the witnesses, I believe, were there as well. A number of attorneys.
This is the Zoom call, I think.
Mirrored that of.
So it would have been before that, a couple minutes, maybe 30 seconds before this.
Okay.
And they informed me that they were not privy to give me that information. Then on January 13th,
okay, you missed
there
it.
was a Zoom call that was requested by Judge Marshall.
You want me to go back?
Yeah, if you would. Yeah, there you go.
And if you allow me just a minute or two to get sorted out. Thank you for apologizing to the victim's family.
Sorry,
it was an
everyone. I'm
emotional
just
day for them,
curious about.
and they appreciate your apology. I know that they took that part out. Thank you. I first want to start with a procedural history of this non-dissemination order, if I could. On January 3rd, 2023, the Judge Marshall submitted a non-dissemination order. And in that order, it applied to parties in the action, which would have been the prosecution, the defense, and any agents, investigators involved in it. After that non-dissemination order was issued, I reached out to the prosecutor's office to see if I could get Judge Marshall's email. For some reason, I don't know if they took it down, but I couldn't find it online. And they informed me that they were not privy to give me that information. Then on January 13th.
Yeah, I misheard him.
There was a Zoom call that was requested by Judge Marshall. That Zoom call was requested at 1 o'clock on the 13th. I received an email at 12:58 from Judge Marshall's clerk requesting a Zoom call.
So he said the 3rd. He didn't say the 23rd.
Yeah.
I misheard him the first time. Okay.
Well, good, man. That's why we do this. No problem. All right, let's keep going through.
The Zoom call occurred at 4 o'clock p.m. During that meeting, the judge reminded us, all the parties involved, it was the prosecution, it was the defense,
And cat though, huh?
it was myself, it was the attorneys for the victims' families, the attorneys for the witnesses, I believe were there as well, a number of attorneys, and reminded us that her non-dissemination order mirrored that of Idaho Rules of Professional Conduct 3.6. As part of that hearing, and I think it's details here, she talks about the rule applies to all lawyers participating in the Zoom meeting, the state and the defense, and all attorneys for the witnesses. When she had that Zoom meeting, and I've requested the transcript from that Zoom meeting and haven't been able to receive it yet from Judge Marshall's court, so we could have a full transcript of what went on that day. But as part of that meeting, I had questioned Judge Marshall regarding the victim's family and whether or not they were allowed to speak to the media based on the fact that she had said all interested parties as well in the initial non-dissemination order. I didn't receive any clarification. I was just instructed to go back to Idaho Rules of Professional Conduct 3.6, as well as I was told, and this is in quotes from her Zoom release, take their duties in utmost regard in conducting themselves and advising their clients. I took that as I should tell my clients to be quiet. She reiterated that again in the Zoom call by saying that I had ethical duties described above in the Idaho Rules of Professional Conduct for commentary of Rule 3.6. And she reminded me later that lawyers have a responsibility in giving advice to their clients. I disagreed with Judge Marshall on almost every point during that meeting. As well as if I had known that we were going to be discussing Idaho Rules of Professional Conduct in those and that issue, I would have prepared, but only having a 3-hour notice to allow me, and not knowing what the subject of the meeting was going to be, didn't allow me to address those issues at that time. Now, after the non-dissemination order in January 3rd, and then the January 13th, 2023 meeting, the judge amended the non-dissemination order on January 18th. And she basically repeated the same order, except for she added the attorneys for any interested party in this case, including attorneys representing witnesses, victims, or victims' families, as well as parties to the above entitled action. So you can see the difference is that the first one dealt with parties to the case. The second one went way over the top, addressing all attorneys that might be associated with the case, or any attorneys that might have an interested party in this case. So that's where we are today. I filed a motion based on that additional language. Now, I'd like to get into some of the issues here. It's very clear that I am not a party to the case, and the victims' families are not a party to the case. That's very clear through all of the case law, as well as.
Can I interrupt?
Hey,
Yes.
hey, Brian.
There's no dispute.
Okay.
You're not.
Hey, so that was kind of an important distinction that
Yep.
he made, right?
Yep.
Is that something that Laura, do you guys have a good handle on that? Is it enough to kind of? I'm just wondering.
It goes back to, I think, the point that we were talking about, where he's been, the G's or the lawyer for the G's complaining that they're not privy to any information that's being gone on. I mean, the judge here is going to probably say something in connection to what he just talked about, but I think it just goes back to what we initially started talking about in the beginning of the stream.
Here, put this.
What do you think, Laura?
It's kind of like you can't have it both ways. Like, if you're not going to give them any info, well, how can you put them under the gag order?
Yeah.
So yeah.
So they started out, right, like attorneys for any, he said first it was attorneys for any interested party to the case. And then it was all attorneys for anyone associated with interested parties in the case, right? Isn't that what he just said?
I can go back.
That just like expands it out to practically
Everybody.
how far does that go?
Yeah, it looks like January 18th, they really expanded the scope of who was under the gag order. So let's hear what he has to say.
Let's go back a little bit and we hear what Judge has to say.
January 13th, 2023 meeting, the judge amended the non-dissemination order on January 18th. And she basically repeated the same order, except for she added the attorneys for any interested party in this case, including attorneys representing witnesses, victims, or victims' families, as well as parties to the above entitled action. So you can see the difference is that the first one dealt with parties to the case. The second one went way over the top, addressing all attorneys that might be associated with the case, or any attorneys that might have an interested party in this case. So that's where we are today. I filed a motion based on that additional language. Now, I'd like to get into some of the issues here.
So some of that was
It's
doubled,
very
right?
clear that
Did you catch that?
I am not a party to the case, and the victims' families are not a party to the case. That's very clear through all of the case law, as well as.
Can I interrupt you?
Yes.
There's no dispute about that.
Okay. Then
your clients are not parties. The only parties of this case are the state and Mr. Kohberger.
Okay,
and that's clear. That's clear in the case law with regard to any victims or victims' families. There are constitutional protections and statutory protections for victims and their families.
I would agree.
That's well established.
So let's get into the actual non-dissemination order itself, how it addresses to me personally as the attorney for the victim's family. This non-dissemination order, of all of the cases and all of the motions that were filed, and referencing every case that was listed in this case, none of them apply to a victim's attorney, an attorney representing the victims. The Idaho v. Tap case was an attorney speaking about a judge who he was in front of. The Good case was a defense attorney that spoke to the media. The Mezabov case was a defense attorney and a prosecutor. The Morrissey case was a defense attorney and a press conference. Varner versus Delahanty was an attorney and a judge, all parties to the case. Cutler was a defense attorney, U.S. v. Cutler. Zhao versus Flop was a defense attorney. Irwin versus Dowd were the prosecutor's actions and speaking to the media. Shepard v. Marshall, Maxwell is a trial publicity regarding the prosecutor's actions prior to trial. None of those things apply to the victim's family or the victim's attorney in any way. Now, I do agree that the court has the power to control those that are parties to the case and that are involved in the case in some way. But we have to define that, what means involvement in the case. Part of that is that the judge referred to the Idaho Rules of Professional Conduct 3.6, trial publicity. She references that multiple times as the basis for her non-dissemination order in this case and how it might apply to me. If you'll read the first paragraph, a lawyer who participates or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. That is not me. It never has been me. It can't be me because I'm not involved in the litigation. She also says
Can I ask you a question about
Yeah.
that? Because, I mean, I think the case law is quite clear that attorneys who are representing witnesses can be restricted to some degree, partly because they have access to particular information that should not be shared with the public. And if I'm recalling correctly, the state has suggested or has determined that your clients are witnesses potentially. So that's kind of the
and I can
issue
address
right
it, Your
there.
Honor.
Go ahead.
As part of that is that, let's just make it clear, the victim's family has never been involved in this investigation, ever from the get-go. After Mr. Kohberger was indicted, we received no information about anything regarding the prosecution, nothing. They wouldn't even tell us that a grand jury was being impaneled for Mr. Kohberger. They told us that there was a grand jury that was being impaneled, and common sense, we figured it out, because he's the only guy in the county. But they wouldn't even relay that information. They haven't given us any information regarding the investigation of the case. But the most critical part of it is that the prosecution has never, ever interviewed the Gonzalez family. So how in the world would we ever be able to be witnesses in this case? And for what purpose would we be? If you're asking about for sentencing purposes, that's post-conviction. That's after he's been convicted on the case. Prior to trial, we're not any witnesses. And that falls into completely different statutes. That falls into the restitution statute. It falls into the victim statute. I just handled that matter in front of the Lori Vallow case, where the judge, I had a motion, the defense did not want the victim's family to appear. And so the judge had to make a determination whether they were immediate family, because it was the grandparents. Completely different statutes because that was post-conviction. And that witnesses, those witnesses were allowed in the courtroom and were involved in the sentencing aspect of it. Okay? So we are in a very, very different factual situation here. I'm not asking as a witness to the case, which witness to the case, they've never ever told us in any way how we would be witnesses in this case, other than the conjecture that we may have potentially. That's not good enough to stop the free speech of the victim's family as well as myself. The other thing is that if the victims can say whatever they want during the free speech and that's exempt, why would I not be allowed to say the same thing that they say?
My understanding is that your clients are not restricted in any way, never have been.
Well, and I'll give you an example.
Is that true?
That's right. Well, I agree now, because that's not the tone of the Zoom meeting.
Well, we're not talking about the
Okay.
tone. I'm talking about the language of the order.
Yes, the language of the order now.
Getting a little spicy now, guys. What do you think? Getting a little spicy.
Yeah, he's ready to say, this is my case now. Let's forget about what Judge Marshall did.
He's getting spicy. He's definitely getting spicy.
Because any interested parties, I asked for clarification. Now I understand that they can say whatever they want. And that's correct. But here's the problem. If they said, we think the judge is crazy, would I advise them against that? Absolutely.
Thank you.
But if I went and said, the family has said that they think the judge is crazy, there's nothing wrong with that. I'm repeating exactly what they said. Now, what comes into play is, for our purposes today, is what if I offer up my own opinion, right? Well, then I'm already governed by the Idaho rules of professional conduct. And if
I'm glad you're acknowledging that.
no, well, every attorney is, Your Honor. I mean, it's not every attorney is. So the idea that I'm not, but every rule doesn't apply all the time. If I'm talking poorly about a judge, another rule might pop in. 8.3, I think is what it is, or 8.1. If I'm saying other things that might affect things another way, then maybe the probability. But the probability, I don't even think applies to me in this anyway. Because if you look at it, it says it applies to a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. And it goes on, highlighted by Judge Marshall, then in paragraph 3.
The thing I want to just kind of pause here for a second, just give some of my own thoughts to the audience. Listen, Shannon Gray is the Gonzalez family attorney. This is what he should be doing for fighting for them. This is as much as people might not like him and say he's sleazy and this and that, he's fighting for that family. He's fighting for their rights. He's fighting for that. So I can't knock the guy on that. He's, in my eyes, he's doing his job as much as people might sit here and go, this is blah, 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 blah. This is what he's paid to do. And, that's what I would expect out of my attorney if I was in this situation. So if anybody wants to on the panel, give some commentary to this and see, if you want to give your thoughts or feelings, I'd love to hear it.
He's not giving up for the Gonsalves family. Yeah. He keeps it going. And I mean, he could have said to them at one point in time, let's just let this go and not say anything. No, he keeps fighting. So I applaud him for really being an advocate for his clients. Absolutely.
AZ, anything you want to add anything? Or
I think he's putting up a good argument, and that's what he's there for. So
100%. 100%. Because I know some people that are probably not going to agree with him, that don't like him. They think he's sleazy. But, listen, if my daughter was caught up in this brutal situation, this is what I would want out of my lawyer. So, yeah, great points. We'll keep playing through this.
Even if the basic general prohibition about lawyers.
I said, I'm not saying he's sleazy, but even if he's sleazy, it's still a good argument.
Absolutely. It's
I almost enjoy how he's using the whole, well, mom said no. What are you going to say, Dad? It's like a mom versus dad thing. And Judge is like, I don't care what she said. This is my court now.
Yep. Real quick, we're at 86 likes. We can just get to 100. I'm going to give away a free membership tonight. So let's get those like buttons. Let's smash those like buttons. Mods, let's get everybody in the chat smashing those like buttons. We'll give away a membership. It's about 122 people watching. We can get this to 100 likes. Come on. All right, we'll keep
going. Statements that no lawyer knows or should know will have a substantial likelihood of materially prejudicing the adjudicated proceeding. And at the bottom of the paragraph, it says this. Rule only applies to lawyers who are or who have been involved in the investigation or litigation of cases and their associates. If I'm not a party to the case, I can't be involved in the investigation or the litigation of this case in any way. So I would argue that the trial publicity rule of professional conduct does not apply to me as well.
Help me understand what you think you can't say that you've already been saying.
I have no idea. I have no idea what
you've been on the media and you've had interviews. So I'm kind of wondering how do you feel that you've been restrained in any way with this order?
I think you're not seeing what the point is. What the point is that
I understand
the court has issued a non-dissemination order that restricts First Amendment rights, that is overly broad in almost every aspect of it. Anybody that's interested and they have an attorney, when an attorney who's walking down the street could offer up his opinion in any way, it also takes away from the idea, doesn't the court want victims' families to have representation, to guide them through the legal process? Wouldn't the court encourage that they could explain things, and maybe advise them on what to say, what not to say? I mean, if you're taking my voice away, you're taking the voice away of everything. The other part of it is this, is that I'm absolutely blown away that the prosecution doesn't agree with me in this case. The reason being is that they are representing the victims, which in turn are the victims' families. And I have not seen a poorer line of communication in my 22 years of practicing than the prosecution's office and the Gonzalez family. And I think it stems from, initially we were critical of the investigation. They wanted to find the person who did this. That's normal emotions. And then from that point on, it has been, we are the enemy. And that's how we feel in this. And so me guiding them and then trying to limit my voice and helping them out in some way, and then throwing out a random idea that they may be potential witnesses when they've never ever interviewed them in any way. It's just an attempt to shut the attorney out and shut the family out, is what it is. Because if I had come to you today and said, we've given 7 interviews, Your Honor, we may be witnesses in this case, done all of these things, it may be a different story. We haven't done anything. They haven't interviewed the entire family. So,
well, I don't know what's in all the investigation, obviously. And
Welcome, Creepy Crystal, to the membership group. Had that 1 free month on me. Has access to all the member videos, all the free member videos. You have access to all of that. So check out that content. We have some great streams over there. Oh, you're welcome. Thanks for being here.
Don't know and probably won't know until the trial.
and the other thing,
And, well, let me just say this. I think one of the potential issues is this is potentially a death penalty case. Hasn't been noticed, but that is a potential. And the families of the victims certainly would be witnesses in that process of sentencing. That is not post-conviction technically, is it?
If your goal is fair and impartial jury.
I want to recognize this. Dr. Bob has gifted a membership out. Just Amber has become a member of the channel. Thank you, Dr. Bob. Thank you for your generosity and the support of the channel. I appreciate it. Yeah, if anybody wants to,
I think he's going to score a point right here, Brian.
Okay. You mean the Gonzalez attorney?
Yes.
Okay, I'm going to back it up just a little bit. If anybody wants to join the memberships, I have memberships for $1.99, supports the channel monthly. It's less than the price of a cup of coffee. I'd really appreciate it. You can go down and hit the join button. Appreciate you. If you're new over here, just make sure to subscribe, hit that like button, and turn on all your bell notifications so you know when I go live. All right, we'll go back to this.
That is a potential. And the families of the victims certainly would be witnesses in that process of sentencing.
So they're arguing about whether or not the families are witnesses.
Okay. Good point.
Because the gag order covers witnesses. And,
right.
And so Gray is saying they're not witnesses, they're family. And the judge is about to argue that right here.
Right. Yeah. He said
even if they're witnesses to the trial, basically.
Right. And even like 5 minutes before all this started, maybe 10 minutes before this started, that's what they talked about as well too, that they could be potential witnesses to the trial.
So I think Gray is going to say, well, they're witnesses to the trial, but the jury is already picked at that point.
Right.
So what does it matter? I mean, then the gag order is not to protect the jury from from witnesses speaking out at that point, right?
Yep.
I think that's the point I think he's gonna win this one.
You think? Yeah, you think he's gonna win it? Yeah.
I think this. Yeah.
Yeah. All right.
We'll see. But we'll see what the judge has to retort. What the judge says back to him. So, all right.
Awesome.
Okay.
No, I love it.
If your goal is fair and impartial jury, right? That's the reason for the non-dissemination order. Well, after the conviction, that goes away.
Well, it's also confidence in the process. So I have that job. I have a job of protecting and preserving the First Amendment and also the Sixth Amendment. And there is some balancing there. That is why lawyers who have access to information that is not accessible by the public have particular restrictions. That's what this whole case is about. In this hearing is about.
And as an officer of the court, I can tell you we have zero access.
Okay, so you're saying that the prosecutor's office has not shared information with your client.
Regarding the facts of this case, no, they haven't.
Yeah, I don't think that comment was right.
Everybody.
Screen.
Sorry.
That last comment on the screen.
This one here.
That the family are witnesses. The judge is saying the families are witnesses, so that means they must have seen something. This crime is way bigger than one dude with a knife. I don't think the judge is saying the families witnessed the crime. I think he's saying they're witnesses to the trial process.
Right.
The judge is not saying that the families witnessed the crime happen.
They were not there. Let's do this real quick. The Richard has joined the membership. He's become a rookie detective. So thank you so much for joining the membership. And let's keep playing through. Good point out there, AZ. Appreciate you.
Is going to have a chance to weigh in on this, and I just
here we go.
You're helping me understand what the issues are. So thank you.
Well, so that's really the issue here. I mean, and this is an important ruling because what you're doing is this has never happened before, ever has it happened before, that a Judge Marshall, has tried to silence the attorneys for victims. Never has it happened that I'm aware of.
Would you feel more comfortable if there was a more concrete description of what people could say and what they can't say?
I don't think you have the authority to, Your Honor.
Well, I think I do have the authority.
Well, my argument is that part of the argument is that.
In fact, I know I have the authority to do that.
Well, and the authority would be through the attempt to have a fair and impartial jury, that you can control people that are involved in the case, correct?
That's part of it.
And we're not involved in the case.
Okay, that's hard to accept. But
we're not witnesses in the case. We're not involved in the investigation. We're not involved in the litigation. I can't file any motions. I can't subpoena anybody.
Hang on one second. I know we're getting really good into this argument. Harlot says, I believe the judge is saying that the G's may end up being a witness at trial. A witness in a trial doesn't have to actually witness the crime. They can also be there to speak on other things.
Yeah, in a court setting, there are three types of witnesses. There's a lay witness that saw something, that literally witnessed something physically. Then there's the expert witness, which we all know what an expert witness is. It's somebody who has a vast knowledge in a certain area. And then there's also the character witnesses, which is where I believe the Gonsalves family may fall under, unless they consider them a lay witness, being that they have information about Kaylee's life before she died.
Right.
Gotcha. Yep. Thank you. Thank you.
Yeah, thank you. All right, let's keep playing through. This is getting good. We're getting spicy here.
I can't cross-examine witnesses. I can't do anything. So this idea that there's this loose idea that there may be, weighing that versus our freedom to speak, First Amendment, is...
We're talking about your speech.
That's right.
Not your client's speech.
But that is my speech. That is part of it, though.
Well, in your memorandum, you are suggesting that you also have an independent position that you are representing yourself.
I do.
It's distinctive from your responsibility to your clients.
That's why the motion is for amending or clarification, because there's the clients that have the free to speak. There's me repeating what they have to say. If they said the judge, we thought the judge was crazy, and I said the judge was crazy, I can't be, it doesn't violate the non-dissemination order because I'm allowed to say that. And then there's my independent voice where I said, the judge is crazy? Yeah, I think the judge is crazy. That goes into another layer, right? Where it would be, Idaho rules of professional conduct would fall into play, and what I would be doing or what I couldn't do. Not the non-dissemination order, because we're not parties to the case. I'd be governed by the Idaho rules of professional conduct if I made those statements, extradite those statements. And I may or may not fall under the probability. I would argue that I don't, because I'm not a party to it. I'm not litigated it, I don't have any information on it, none of those things. So really, that's where the authority for me, for my voice, would come from the Idaho rules of professional conduct, if I did that. And if I made a statement that I thought didn't apply for trial publicity purposes, that would be an argument for another day. But it wouldn't be for you, for a contempt of court for me, because I'm not a party to the case and I'm not involved in the case in any way. I'm just repeating what my clients say, or I'm just saying my own individual opinion, which doesn't, by the way, makes it absolutely unduly prejudicial. Because what if a guy is on an Idaho bar member, is walking down the street, looks up, sees a television program where the Gonzalez family says, well, we thought the judge was crazy, right? And then all of a sudden, the media is outside, they interview him, they say, hey, you're an attorney here. What about the judge being crazy? Well, I've been in front of him 3 or 4 times, and I would agree with him. You're going to sanction him and contempt of court? You can't. Same as me, because I'm not a party to it. He's not a party to it. He might be governed by the Idaho rules of professional conduct by commenting on you, Your Honor, but it wouldn't be because of the judge's non-dissemination order. So how can it not apply to him, but it can apply to me? It can't.
Well, the case law suggests that because you represent potential witnesses, that you have access to information that may not or should not be shared with the public. That's what the case law says.
And I would argue this: what potential witnesses are we, number one, and what access to information do we have? I think the defense has argued that we have some sort of access because the clients can tell me whatever they want to tell me, right? Well, that's free speech. They can say whatever they want to me, and I could go off and say whatever I want that they said, because it's free speech. It's the First Amendment. So you can't, this non-dissemination order is so broad, none of the case law applies to people that are outside of the defense or the prosecution. That's the point of it. That's the whole point of a non-dissemination order, because they have access to it. They have access to the information. Victims, attorneys, families do not. And the idea that we may or may not be a potential witness is enough for Your Honor. I just can't see that, especially when there's no history of them ever being a witness. And to tell you the truth, the day after they filed that notice, or the day before they filed the notice that we may be potential witnesses, we had just gotten out of a meeting with the prosecutor's office, discussing whatever we could discuss, like our concerns, because that's all we do is go in and talk about our concerns, and they tell us we can't say anything, we can't say anything, we can't say anything. We'll get to it. When we walked up, nowhere in that meeting were we described as being witnesses in this case. But all of a sudden, the next day, they thought we might be, even though they'd never interviewed us. So they're throwing stuff in the air. The king's not justified, and the idea that he thinks maybe might is not enough to regulate my free speech in this as the attorney for the victim's family, because that's what we are. We're not attorney for witnesses, we're attorney for the victim's family. And if the court has any other questions, I'd be more than happy.
I understand your position.
Sure.
Thank you, Mr. Gray. So let me go to the state. I don't know if that's Mr. Thompson or Mr. Rutland.
It'll be me. Can I have one moment, Your Honor?
Certainly. Thank you.
If I may,
Yes, you may.
Mr. Rudley is actually going to be arguing on the motions themselves, but as attorneys, we have a duty of candor to the court. Mr. Gray has made representations to the court that at best are misleading and in many ways simply untrue. I need to correct them for the record.
This is going to get really interesting right now. So really pay attention here, because you got like, it's funny, the defense is just kind of sitting there listening, and now you're going to have these two attorneys kind of battle it out. You have the prosecution with the Gonzalez family attorney, so it's going to probably get spicy here now. If you like courtroom drama, this is what we come for. So sit back and relax. It's going to get interesting.
This year, I do not want the public to come away with the impression that improprieties have occurred. First, Mr. Gray, on behalf of his clients, has propounded a number of questions to our office and investigators. We have answered the ones that we can. We have not shared ones that we are concerned that Mr. Gray or his clients would make public and compromise the integrity of the investigation. For him to say that we've provided more information is simply not true. Secondly, he claims that law enforcement has not interviewed his clients, that somehow that is the investigator's fault. In fact, from the very beginning, the investigators have attempted to interview his clients, and Mr. Gray has not permitted it. So just for the record, I want to make sure that's clear. Thank you, Your Honor.
If I could speak to that, Your Honor.
You'll be able to come back in after you hear the other
Thank
arguments. Mr. Rutland, go ahead.
Thank you, Your Honor. In State v. Spencer, the Idaho Supreme Court noted that it is also the duty of the prosecutor to ensure the right to a fair and impartial trial. Under the dictates of Shepard v. Maxwell, the court has a duty to take affirmative steps to address the impacts that intense pretrial publicity can have on a case. As noted in Shepard, Nebraska Press Association versus Stewart, and their progeny, an order like the one in this case is an appropriate measure for addressing that duty of the court. As Mr. Boston's experts have noted, attorneys often have information about a case that may not be appropriate for dissemination in the press. Additionally, attorneys carry a greater weight when appearing on television. For instance, what might be easier for the parties to address is a juror that says, I've seen coverage on the case, but I don't always trust what I've seen on TV, and I can set that aside. What's more difficult is a juror that says, I've seen attorneys for the prosecution, attorneys for the defense, or attorneys for the victims on television talking about a critical aspect of the case. In the matter of Gentile versus State Bar of Nevada, that case involved an attorney who held one press conference in 1991 after the indictment of his client. In this case, Mr. Gray's repeatedly issued statements and been on television. At minimum, it's insincere to argue that he's feeling bound by the order when it's clearly not abided by. In Gentile, the court noted that the speech of attorneys is subject.
Real quick, do you think the defense enjoys this, that these two lawyers are basically, well, the prosecution and the Gonzalez families, like eating each other alive here?
Oh, 100%. Look at their micro expressions. Look at Elise. I believe that's Alyssa Massoff there with the dark hair. Yep. She's loving this.
Oh yeah. And then the other gentleman here, the gentleman sitting here kind of with his hand like, you know, like they're Ann Taylor's been just straight ahead the whole entire time. I mean, but they're probably deep inside just kind of laughing that this is going on. But we'll keep playing through. We're gonna wrap this up. This probably about 15 minutes, and then maybe we can take a question or two from everybody before we head out.
Subject to less substantial, or it can be regulated by less substantial means. In this case, as we've shown by the affidavit we filed, the Gonsalves families are potential witnesses in a trial, or more specifically at sentencing. The order in this case is not vague, overbroad, unduly restrictive, or not narrowly drawn. It precludes all extrajudicial statements of the attorneys in this case, attorneys for the witnesses, victims, law enforcement, and investigators. The order addresses, if the court were to apply strict scrutiny, the order addresses a substantial likelihood that pretrial publicity poses to the integrity of the judicial system, and is.
I'm gonna say real quick that Judge kind of looks like Harry Anderson from Night Court.
Yes, he does.
Doesn't he kind of look like him? I'm like, he looks like the guy from Night Court.
Yeah, a little bit.
Wonder if he knows any magic.
Yeah, right.
To ensure that the rights to a fair trial are upheld. As we briefed in the case of Levine, the alternatives such as sequestration of the jury or changing a venue aren't going to mitigate the impacts of statements, extrajudicial statements in this case, and are unlikely to do so.
Everybody's agreeing.
Thus, the state contends that the order is an appropriate measure of the court to uphold its duty under Shepherd, Nebraska Press Association, and the like to preserve the right to a fair and impartial trial. At a minimum, Mr. Gray's statements that he's not bound by trial publicity rules or 3.6 in this case illustrate why the order of the court is necessary in this matter. And so we would ask that the court uphold the amended non-dissemination order, or at most tailor it to those statements specifically precluded in Rule of Professional Conduct 3.8. With that, I'll stand for questions.
Thank you, Mr. Redley. Do you think that would be helpful to just, and I asked Mr. Gray this same question, would it be helpful to say, okay, you can say these things, but you can't say these things, and be more specific about that?
Your Honor, our initial position is that the total prohibition of extrajudicial statements is the safest and most responsive way in this case to address and preserve the right to a fair and impartial trial.
All right. Can you go back? You mentioned this about the standard particularly applying to the lawyers who are somehow connected with the case.
Yes, Your Honor. In Nebraska Press Association v. Stewart, it's noted that I believe Justice Brennan states that there's no doubt that the court has authority, though it's in a footnote, it's no doubt that the court has authority to regulate the speech of attorneys, witnesses, and other participants in the court process. At this point, the evidence that's been provided is that the family would be potential witnesses in the case, as Mr. Thompson mentioned. We haven't necessarily been able to make a full assessment of that, but undoubtedly they'd be witnesses in any sentencing.
And what about the standard? Strict scrutiny?
Yes.
Or lower standard?
Your Honor, we would argue that the court should apply the standard in Gentile versus State Bar of Nevada, where the Supreme Court stated that, I don't want to mess this up quick here, that the speech of lawyers may be regulated under a less demanding standard. So we would argue that so long as the court finds that it has a duty under Shepherd to preserve the right to a fair and impartial trial, that the order addresses the substantial likelihood that that negative pretrial publicity would have on that right, then the court would have authority to impose the amended non-dissemination order.
Thank you, Mr. Evans.
Thank you.
Mr. Watson.
Judge, I think a lot of that is said, and obviously you wrote a lot in the briefing, so I guess I'll just touch on a couple of things. In terms of the argument that the victims' families are not involved in the litigation of this case, and therefore don't fall in 3.6, would be our position that if you have statutory and constitutional rights involved in this case, you're involved.
Just about another 10 minutes here in the hearing, and then we're going to take just a few questions before we wrap this up, probably to get this wrapped up before 11. I appreciate everybody hanging in and hanging out with us this evening. I know we're not talking a lot, but we really wanted to just listen to this hearing, give some opinions on it, and just kind of see what was going on today. And of course, if there's any other court hearings that come out and they're televised and recorded, we'll obviously play them here. I just want to take a moment really quick and just again thank my panel guests for being here, my mods for hanging out on the panel this evening, and all the new subscribers, all the new members that have come over the channel. The channel's growing, it's growing fast. We really appreciate it because we put a lot of work and hard work into this. It's not only my channel, it's my mods help an extensive lot behind the scenes to put all this presentations and all this material together and to actually open themselves and come on this panel. So I commend all my mods in the chat that have wrenches. I appreciate all your hard work. You're always here for me. And then when I can call and say, hey, does anybody want to come hang out on the panel? Please do. I also want to say this as well, too, just really quick, is that, we're not attorneys. We're not law enforcement. We're just a group of people that stick to the facts in the case. We read through the case files and we base our opinions off the case files. We don't like to put any type of false information out, conspiracy theories, stuff like that. We just don't deal with that here. I get it. There's other channels, there's other media outlets, there's other people that just do really deep dives into this stuff. We keep it like a courtroom here. And if you're looking for really crazy deep dive stuff like that, you're probably not going to find this here. We may take scenarios based off legal documents and do a presentation. We had some great ones when we talked about Xana Kernodle, the night of the murders, and a few other ones that we put together. It just doesn't come to mind because we've done so many of them. But again, we stick to the facts here on this panel. We keep it balanced. And we try to keep everything as fair. And we have a really great group of people that come into this chat and join us. So again, we're just a water cooler kind of conversations here. We are really invested in this case. And ultimately, in the end, we just want to find justice for these victims and justice for Bryan Kohberger if he didn't do this, and I want to stress that as well, too. He is innocent until proven guilty. Laura, I saw your mic go off. I don't know if you want to comment.
Well, it's a pleasure coming on here. It's definitely, as weird as it's going to sound, it's changed my life. It's changed the way I look at things. I have a new group of friends. So I enjoy this very much. And thank you so much for this opportunity to have. And truly, at the end of the day, it is about those victims' families, not just, not just the Idaho 4 victims' families, but also other cases we've looked at, other cases that are out there, cases we may look at, being able to go live and have something out there, an artifact that people can come across and look at, take it all in, and providing them with good information that is fact-based with, of course, with some speculation, is wonderful to do this. So as my tagline says, just the facts.
Yeah, exactly. AZ, anything?
I'm digging it. Having a good time. A little behind on the gag order, I'm finding. Gonna have to get boned up. Thankfully, the chat's setting things straight for me.
Yeah, of course.
So many aspects to this case, you know. I mean, you'd have to be pretty much getting paid full time to stay on it all, I think. And then even then, good luck.
Yeah, and listen, we don't get everything right. Believe me, we're not perfectionists. We're not, there's things that we get behind. I mean, I work a normal job. Everybody here works a normal job. So this is, I don't want to say it's our hobby, it's our passion. And we spend a lot of time in this. And I don't know, I guess those could be two things in a sense, right? Hobbies and passions. But, we want to treat this fair. We want to treat it fair in the respect for the families and respect to the accused until they're either proven guilty or innocent. So, we all have our stance, how we stand in this case. I think I've been pretty open about where I stand on this. I feel like the evidence is strong against Bryan Kohberger, and I may be proven wrong, but that's my opinion. We'll go from there. I won't spend too much more time. We'll try to wrap this up, and then maybe we'll take a couple questions before we close the stream down. So enjoy this last 10 minutes.
Regardless of whether or not the prosecution is willing to work closely with you or whatever issue you have there, the reality is if you have literal rights that permit you certain things that are involved in this case, you're involved in litigation, and therefore you fall within 3.6 just like everyone else. Second, the standard from Gentile is the substantial likelihood of material prejudice. I don't want to get too much into that, Judge. I think that's kind of this afternoon's argument. I think the main thing before the court, as far as Mr. Gray and the family, is just, do they fall within this, and then the court to decide what is appropriate. But I would note that given the vast amount of media coverage in this case, and the fact that it seems like no matter what anybody says or does, in one way, shape, or form, it will be twisted into an attack on my client. We also agree that at this point, the safest thing to do is for everyone to just not be talking to the media and allow statements to be made here where we all get a chance to speak, and the media gets all that information. If they still choose to do what it is they've been doing, then that's on them. But we don't have somebody who's just trying to whip the media into a frenzy and send this case to the firing squad or however it is. So that's our main concern. The only other thing that I wanted to address, and the court addressed this a little bit, the reason we stand silent with grand jury indictments is because there's an old arcane rule that says that if you have a grand jury indictment and you enter a plea, you are accepting the validity of the indictment. I haven't seen a prosecutor try to use that in a long time, but we can avoid any possible claims that somehow we can't challenge anything with the indictment by simply standing silent and having the court. So, just so that everybody's clear, that's what. Does the court have any questions for me?
I don't think so, but thank you for that additional education.
Thank you.
All right, Mr. Gray, it's your motion, so you can respond to what other counsel expressed.
I guess the first thing I would want to address is the prosecution's idea that I haven't allowed our clients to speak with the investigators. You'll realize that the date of the incident, I wasn't retained on this case until close to December 5th, which will be more than 3 weeks after the incident occurred. And they still have made no contact as far as investigating and interviewing the victim's families. So somehow that I precluded that in some way is just not true, Your Honor. And as far as scheduling those things, I'll just leave it at that. The second part is everyone is quoting the Gentile case. The Gentile case is exactly like all of the other cases. It says over and over, it has to be a lawyer participating in the judicial proceedings. It has to be a lawyer who represents a defendant involved with the criminal justice system, a lawyer actively participating in trial, a lawyer who's participating before the courts can only be limited if he's participating in front of the courts. None of it applies to me.
Seems like you're in court right now.
Because you're the one that brought me here because of the non-dissemination.
You brought yourself.
Yeah, well,
you're the one who filed the motion.
I did file the motion because the non-dissemination order is unconstitutional.
I'm just trying to clarify what you just said.
Well, this will probably be the only time I'm allowed because I won't have the authority to file any other motions on anything else in this case.
Why
Because,
would you say that?
well, because I'm not a party to the case.
You can still, I mean, the media is not a party of the case either.
Once
But
again,
well, the Supreme Court has said they have standing to come into the court and address issues. So,
yeah, but that's completely separate. They're not.
well, I know it's separate.
Okay, so.
I also respect your position in representing the families, the victim's family, and I respect that. And there are some constitutional issues, rights that they have. So I'm not just dismissing that.
And the mere fact that you have a right, I'm absolutely positive that the Idaho legislature and the Constitution, when they gave victims rights, didn't think that that was implementing those victims into the trial in some way. Absolutely positive that wasn't the intention.
Totally agree with that.
So this idea that if you have rights, then you're involved is just beyond. That being said, Your Honor, nothing precluded the prosecution from contacting my clients well before I was representing them. They had almost 3 weeks to contact them. I think, don't mark me on this, I think I was retained on December 5th. I think that was the day. I don't have my file in front of me, but it was holding me to it. But I think that was the day. So they had plenty of time to contact my clients and interview them if they were going to be potential witnesses in this case. And since then, every time we have had a meeting, we have initiated that conversation. It hasn't been the prosecution initiating that conversation.
So are you saying since you have been representing your clients that the prosecutor or investigators have not asked for interviews?
I would say this, in the meetings that I have had with the prosecution's office, I have asked, as part of that, whether interviewing my clients might be an issue. Would they like to do that in some way? Offer that up in some way? And they've never taken this up. And maybe a random email here and there that says something and no follow-up whatsoever about it. So this idea that they are going to be witnesses in this case is just an attempt by the prosecution to shut them up as well as to shut me up. And by the way, people completely forget about this. All of the information that has been disseminated to the public from the get-go was the mayor, Art Bedke. Chief Fry had interviews. Bill Thompson had interviews. The coroner had interviews. All of those people had interviews. We didn't until we started getting information and started trying to figure out what was going on after they had given interview after interview after interview. That was the purpose of the judge issuing the non-dissemination order, is to quiet them up, not quiet the victims up. They had no control over that investigation from the get-go.
Well, that order was a stipulation between
That's
the state and Mr. Kohberger.
That's the other thing, though, is that the court, after that Zoom meeting, Judge Marshall incorrectly said that that was stipulated by all parties. I never stipulated to that. I emailed the
You're
judge.
not a party.
Exactly right. I'm not involved in the
The
case.
stipulation was between the parties. As
So,
you correctly stated who the parties are.
so we would
I
ask,
agree, but you were suggesting that it was entered to shut down the prosecutor's office.
why would they
That's what
claim?
you just said.
I do think that part of the, that was part of the process, is that they understood that their investigation was getting out of hand. Too many people were talking in their investigation, and that's why they stipulated to it. Yes, I do.
When you say they, you mean the prosecutor's
Yes.
office.
Yes.
All right.
Do you want me to give you a final, or do you?
Go fight
Okay.
it. You go.
We're not a party to the case. You're very aware of that. I have the right to repeat what my clients say to the media. I also have an independent right governed by the Idaho Rules of Professional Conduct regarding those individual rights versus my own opinions. But those opinions, I don't firmly believe, would fall under the publicity rule. on the Idaho Rules of Professional Conduct because I'm not litigating it or part of the litigation. And the reason those things are in place are because people that have real privy information regarding the prosecution and the defense, which I don't, which my clients don't in any way, it shouldn't apply. Thank you.
Thank you, Mr. Green. All right, well, I'm not going to issue a decision today. I'm going to issue a written decision. There is a lot of briefing, and I've heard some very interesting argument today. And I'll get that to work and try to get a decision out as soon as possible.
All right, I'm just going to close this up because it's basically just going to dismiss court here. And just real quick, I wanted to just play this really quick because this was in the beginning. We actually didn't see it in this video, but here's a brief entering of Bryan Kohberger today in court. You get to see him in the full suit. Let's play this really quick, and then if we can, before we close this up, maybe we'll take a couple of questions. If you guys have any questions, type Q and then your question. We'll answer a few questions before we go off the live. I don't want to spend too much more time because we've done almost a 2-hour stream, and I like to keep these down. Let's play this. We'll give you guys a little bit of time to type some questions, and then we're going to get out for the night. So let's play this really quick. This was Bryan Kohberger entering court today. Okay, we'll let this kind of play out as we're taking questions. So we have a question here from Soulshine. Maybe we can answer this. Will they be moving the trial? And if so, will he retain the same public defenders? I don't think there's been a ruling on that yet.
No, they have 30 days from the date of the indictment, I believe. So they're running out of time for a pretrial motion for the change of venue. He will retain the same public defenders. It will be the same judge. So the only thing that changes with a change of venue would be the juror pool.
All right. And we have another question here from Duck Farts and Truth. Question: when do you think, if so, will the defense request a change of venue?
Well, I'm actually going to look at this right now.
Yeah, if anybody else has any other questions, pop them in there real quick before we head out for the evening.
I'm sorry.
Yep, go ahead.
He was indicted on May 16th, so they have 30 days. So that would take us to June 15th.
That's quick.
So we, according to everything, unless they file, with them filing all of the motions to extend things, they could, but here it is. They enlarged the motions. They have 30 days from the receipt of the grand jury materials to file any pretrial motions. So so from the receipt of the grand, so that takes it to June 18th, given they received the grand jury materials on the 19th.
Right. Question from Can I Kick It? Do you think the judge's chair is comfy enough? I'm playing. That chair looks nice. Absolutely.
It's a very nice chair.
A lot better than mine, I can tell you that. Maybe we'll take a few more here. We'll wait a second, and then we're going to wrap this one up. Let's see. Oh, wait. maybe about 30 more seconds. And if not, I know it's late for everybody. I appreciate everybody hanging out again. If first time over here, make sure to subscribe. If you want to join as a member, you can go down there and support the channel monthly. You can hit that join button down below, super chat, any of that fun stuff, super stickers. We appreciate it. I'm going to tell the results of this poll really quick. So I had to ask the audience, should the gag order be lifted? 72% said yes. 27% said no. We had 85 votes to complete. When are we going live tomorrow? I haven't made a decision up on that yet, but I do have some time in the afternoon to think about if I'm going to do a live stream tomorrow. Maybe I'll come up with something. I'm tired. We've been burning the midnight oil over here. We've been discussing this case at length for the last 2 weeks, and I've been working 65 hours a week right now. So on average. Let's see. It doesn't look like we have any more questions. I appreciate it again, everybody for hanging out, new subscribers, new members. I want to thank the panel again. AZ, thank you so much. Laura, thank you so much. We will be back at some point. Maybe I'll pop a stream up tomorrow, but it was probably going to be another late one. But if not, we'll be back on Sunday. Or at least I know I'll be back on Sunday. And yeah, any parting words, guys?
Enjoy your Friday night. Enjoy your Saturday. We'll be back soon enough.
Absolutely. AZ, anything?
It's getting interesting.
It's getting spicy. It's getting spicy. And we'll end on that. It's getting interesting. And indeed it is. All right, guys. Everybody have a good night. See y'all soon.